Good morning, one and all. I, Chandraprabha KS, Assistant Professor, Department of Computer Science and Engineering, SIT. So, it's my pleasure to welcome you all for the talk on cyber crimes and cyber laws. This talk is arranged mainly to give you a flavor on different field apart from the webinars, guest lecturers, technical talk on our own computer science domains. So the objective of this talk are to empower the users of internet in India to be more sensitized about the emerging trends on cyber crimes. So to create awareness on all kinds of cyber crimes which are targeted against the persons, property or the nation. Hence this talk is arranged. So I also take this opportunity to introduce today's speaker, Dr. Sreenivasulu N. Sir profile runs to the 51 pages, but due to the time limit, briefly I will introduce the today's speaker, Dr. Sreenivasulu. So currently, Dr. Sreenivasulu NS is working as a professor of law at National University of Juridical Sciences, Kolkata from past 7 years. He has done his PhD on biotechnology and patent law with reference to the legal systems of United States, European Union and India from the University of Mysore, Karnataka. He is a distinguished member of International Council of Jurists, London, and he is a scientific member of Canadian Institute of International Law, Ontario, Canada. He is also associated with the World Commission for Human Rights, London. So Professor Sreenivasulu NS was a faculty at National Law School of Indian University, Bangalore and University of Mysuru before he was selected as Associate Professor at NUJS, Kolkata in the year 2007. And he was promoted as Professor of Law with effect from the year 2013. He has been a recognized author and has got to his credit 107 research publications, including 7 books published by peer-reviewed and reputed international publishers, 3 monograms, 9 edited volumes, 15 book chapters, and 73 research papers published in more than 35 varieties of journals and international publishers such as Oxford, London, UK, Indiana, USA, Springer, UK, Butterworths, New Delhi, and many more. So he is specialized in intellectual property laws, biotechnology law and information technology law, multidisciplinary interfaces of law and policy, civil liberties. So his current research interests include generation next reforms in legal education in India, international aspects of intellectual property law, law and policy reforms with the development agenda, Indian and contemporary legal thoughts, and evolution and functioning of law. So with this brief introduction, I will hand over to you, sir. Please begin the session.
Thank you. Thank you, Siddaganga Institute of Technology, in particular the Department of Computer Science, for organizing this webinar from top on cyber crimes and cyber laws. I am given to understand that the beneficiaries, the targeted audience of this particular webinar, actually coming from the background of computer science or information technology. Keeping that in mind, I have tried my level best to structure my talk to fine-tune or to have compatibility with the kind of background that you all, the audience, are having. Cyber crimes and cyber laws. In the contemporary world, every individual, irrespective of their status and background, they are connected directly or indirectly with the cyberspace. Because they are depending on the cyberspace, they are vulnerable. They are also prone to not only get addicted to the use of cyberspace, but as well become vulnerable or tools in the hands of the people who use cyberspace for illegitimate purposes, for the purpose of committing cyber crime or for making illegitimate money by cheating, misusing these cyberspace. And as such, this talk would throw some light on the kind of cybercrime that we generally come across and the kind of law that is in place which intends to regulate and prohibit misuse of cyberspace.
Sir, sorry for the interruption. Can you please talk a bit louder and increase your volume, sir?
Okay. Yeah. Is it fine now? Yeah.
Sir, talk,
Yeah,
sir.
I've given the maximum sound on my.
Yes, sir. Yes, sir. It is louder now. Thank you.
Yeah. Sorry for that small break. The cybercrime, as I mentioned, has become more or less a common phenomenon for all those people who are actually involved with the use of cyberspace in their daily routine. But we have a law which is called as cyber law or information technology law, which intends to control, prohibit, punish the instance of some cyber crimes. Here it is very much pertinent to know in not only general terms but as well through the lens of law regarding what is cybercrime, what are the different ways and the means of committing cyber crimes, who are the people who are actually prone to become victims of cyber crimes, what is the legal canopy which is in place for the purpose of combating cyber crimes, and also what is the established law in this regard. So for this talk, I have identified a few issues around which the entire debate will be revolving. At the outset, I have identified 4 different issues. The first one is what is cybercrime and how it is different from the crimes that are committed in the regular sense or the crimes that are committed in the physical world. How exactly cybercrime, which gets committed in the virtual world, is different from the crimes that get committed in the physical world. Issue number 1. Then what are the ways and means of committing cybercrimes? When exactly, how exactly cybercrime gets committed? What is the platform? Whether without aid and assistance from the technology, which you call as misuse or illegitimate use of technology, can the cybercrimes be committed? So what are the means and ways of committing cybercrimes? Issue number 2. What are the repercussions of cybercrime? That means effects of cybercrime, not only on the virtual world, but as well in the physical world. Because it is the physical world which is hosting the virtual world. Through the means of connecting some material objectives, material components, you are bringing into existence this cyber space or cyber world. But the law is, what we actually want to realize is, in which physical vicinity the computer is connected, in whose control the computer or the internet is being operated. Why? Because your cyberspace, your internet doesn't have any physical existence. For fixing liability, the law people will always try to think from the perspective of where the computer is located, where the computer is physically located, or who is actually controlling that computer. What are the equipment which are connected to the computer, which are having physical existence. So the cybercrime repercussion will be there on that individual who is controlling in that place where it is located on that. That's why, what are the repercussions of cybercrime in the physical world? Issue number 3. Then how to combat cybercrime? Whether it is possible to combat cybercrimes by spreading awareness about the misuse of cybercrimes, or it is required that beyond spreading awareness about the use and misuse, we need to have some sanction, some liability, some obligation imposed upon the people who are actually hosting the computer, who are actually facilitating the computer and internet, or the people who are actually having the control of that locality place where the computer is located and connected with the internet. Issue number issues that I will be building on, debating on, trying to find a solution to during the course of this 1 hour in this debate. Further, there are certain attention areas. In the next slide, if you can look at, I have identified certain attention areas as far as the cyber crimes and cyber laws are concerned. Wherein there is some impact of information technology in the contemporary world, which is going to fill the gap between, or which is going to connect these two phenomena, cyber crimes and cyber law. It is the information technology by using which cyber plays is brought into existence. It is the information technology by the misuse of which cyber crimes are committed. It is the information technology by using which cyber laws can control cyber crimes. So, attention area number 1 is information technology use and misuse. Misuse of information technology results in cyber crime. And for that, controlling that misuse of information technology, again, we have to use information technology only for the purpose of implementing, executing cyber laws. Right? So, the attention area number 1 is raising or mapping the impact of information technology in the contemporary world, which is the reason for both committing of cyber crimes and as well controlling the same through the lens of cyber laws. There is another attention area, that is use and usage of information technology. The width, the bandwidth, or the length, duration of using information technology, or the frequency of using information technology in our daily routine is also a reason why we are becoming victims of cyber crime. Use of information technology, immense use of information technology, widespread.
ಆಡಿಯೋ ಬರ್ತೈತೆ ನೋಡಿ.
The flavor of the fabric of contemporary world, every individual, irrespective of the fact whether they are laymen or lawmen, whether they are literate or illiterate, what kind of background they are from, dependency on information technology for daily communication or for continuing their regular lifestyle has become order of the day. So such dependency is also a reason for this menace of cyber. Or not only depending, that dependence is resulting in not only use but as well misuse of information technology. So you are not as a lawyer, from the legal perspective, you would like to analyze, please differentiate between crime in the regular sense and also crime in the cyber sense. Before we go about analyzing what is the crime in the cyber sense or in the virtual place, cyber crime as such, it is very much pertinent to understand what we actually mean by crime in the regular sense. Crime is an illegal act which is committed or done, taken up with a modified intention. It is a prohibited act, it is an excluded act, it is forbidden or illegal act by the government under the lens of the law. And it is called a crime because it has been taken up, executed with a modified intention. For meeting an unlawful purpose, for getting an illegal object to obtain. Not only that, but as well to ensure that you cause some loss to the person, reputation, property of somebody else, some other individual, some other entity, including the government. Right? So an illegal act you are doing with an unlawful purpose, qualified intention, illegal objective for the purpose of not only benefiting you through illegal means, but as well causing damage to somebody else. Right? Two different purposes. One is to benefit you illegally, and as well to damage the other person, other entity illegally. This is what we generally mean by crime in this general sense. Right? You are undertaking a forbidden act for the purpose of achieving an illegal objective, illegal purpose, for drawing some benefit for your purpose, and as well illegally damaging others, others' reputation, others' property, others' personality, etc. So this is what we call as crime in the general sense. There are certain ingredients for this crime in the regular sense, because this ingredient may not be present in the context of cybercrime. In the context of cybercrime, the kind of ingredients we talk about from the lens of the law may not be having symmetry with the kind of ingredients that we get to see when a crime in the physical world is committed. For example, we use the terms mens rea and actus rea. In legal terminology, mens rea means mental intention, motive, intention, mental intention, mens rea. Actus rea, execution, or executing the action, actus rea. That means you should have the intention and as well the execution. You should have the intention to cheat somebody, you should have the intention to do illegal act, and as well you should have executed it through your own hands or through your own intention. Then we call it as that the crime has been committed. The individual whom you call as a criminal is not only having an intention to commit a crime, but actually has committed also. Both intention and as well execution are there. Then only we say that crime is committed in the physical world. But it is not the same in case of cybercrime. Because in case of cybercrime, it is very much difficult to prove whether you had the intention or whether you have executed it. Right? In case of physical world, we say that you have the intention and you have committed the crime. It is very much required, and as well it is possible to prove that the individual who is the alleged person, alleged criminal, has not only executed the action which has resulted in some damage to somebody or particularly benefit to the individual who has committed the crime, but as well that individual had the intention. So both the mental intention and physical action, right? Mental action and physical action, both can be proved, both are essential to prosecute an individual as a criminal for the offenses or crimes committed in the physical world. But what happens in case of cybercrime? Whether the length of the law would call for determining or ascertaining the presence of mental action and as well as physical action, mens rea or actus rea, or it is not required that mental action or mens rea, whatever we call it as in technical terms, it is not relevant in the context of cyber crimes. It is only the action, whether you have done it with intention or without intention. Some action you have done and it has resulted in some damage. As long as the damage is there, as long as we have caused some harm to the other individual by damaging that individual's reputation, harming the property, damaging the property, whatsoever it is, there is some damage, when there is some execution, you are going to be responsible for that, irrespective of the fact whether you have mental intention or not. Number two, in case of physical world, when you damage other person, you will damage other person's property, other person's land, building, or vehicle, whatsoever. All these things are having physical existence, material existence. Those things can be seen, possessed, captured, held, or experienced. But in case of cyber world, in case of cyber crime, most of the properties with reference to which cyber crimes get committed, these properties are not having any physical existence, unlike your land, building, vehicle, right? Your mobile phone, like that. Properties in the online world or properties with reference to which cyber crimes get committed may not be having any physical existence, right? purpose of analyzing, understanding, prosecuting cyber crimes, you need to know, you need to remember these three things. Physical or non-physical existence of property with respect to which cyber crime is committed, presence or absence of mental intention to commit cyber crime by the netizen, right? By the users of the internet, who we call as netizen. And number three, action. Whether action has taken place, whether action has been executed, crime has been committed by the individual who intended it to commit, or other individuals who accidentally happen to do that, right? Because cyberspace has got universal jurisdiction. It has got no boundaries. No single country can have the control over the cyberspace. Cyber crime can be committed by you people being in Bangalore. One can commit crime in Bangkok, or for that matter, Australia. Unlike the committal of crimes in the physical world, where you cannot imagine committing the crimes in a lengthier pedestrians, and it is in that reason it is easier to combat regular crimes, because nations have individual jurisdiction, your local police will have control, you cannot go beyond a particular length and level in terms of physical or geographical boundaries, and as well you are committing the crime with reference to something which has got physical material existence. Something has been stolen, something has been damaged, that has got physical existence. So it is easier to map the damage as well. When you damage property, the land, building, or vehicle, it is easy to map the loss also, because there is no physical existence. But in case of cybercrime, you are committing cybercrime with reference to some object which has got no physical existence. It has got no physical existence, and how you will assess or how you can compound the damage that has been committed. Right? So like this, these are certain things which we need to analyze and understand with respect to understanding cyber crimes, and as well from the length of the law, from the prosecution point of view as well. These are the features the prosecutors will look for in determining or in prosecuting cyber crimes. No material or physical existence of properties on cyberspace. It is not possible to prove mental intention on the part of the individual who is actually committing it, right? And it is not easy to locate the place where the cyber crime is committed. It is not that easy to take control of those connected computers or states where from the action has been initiated, oriented, right? You may initiate the action from some place, and at the end of the day, the result you may feel in some other place, right? Nowadays, people are using software also, logical bombs, Trojan horses, etc., different methods, different programs you are designing for the purpose of committing cybercrime, right? The designer will be different, executor will be different, right? Assume that you have coded for a particular language by using which you can transfer the money from one account to other account. You are the software engineer. We have coded on the board that working with algorithms and the coding, whatever object code, source code that you come across in case of a particular program, and you have, right, reduced it into a CD or a pen drive whatsoever. You sold it to somebody, and that somebody happened to authorize, give it to some other person, and that got stolen by somebody. And with that stolen software, another person happened to execute that the bank, illegal bank money transfer. Now, whom you will catch? Right? This is a stolen software, and that the stolen software was lost by the agent of the owner, and the agent has got no connection whatsoever because the owner has filed the agent, and the owner happened to purchase it from some retailer, and that retailer happened to purchase it from the bulk agent, and that individual happened to import it from somewhere. Right? In this kind of hypothetical example that I'm giving you, you understand the pain of the prosecutors in regulating and combating cybercrime from the catch. Right? That's why we talk about these glaring features which are prevalent and present in the context of cybercrime. Of course, at the end of the day, the legal frontiers have arrived at a logical or established law on this point. But I'm trying to present you the different scenario altogether with reference to cybercrime, right? Going forward, let me terms of the law, we divide or we categorize or classify cyber crimes into 4 different categories. Cyber crimes against the person, individual, cyber crimes against the property, cyber crimes against the reputation, cyber crimes against the state, society, including government, right? So, crime against the person, when I say crime against the person, that is against the person's status, personality, right? That individual's privacy, what for you? Right? Here you come across the harming the individual's privacy, trespassing into that individual, trying to have surveillance over that individual, keeping a vigil on that individual, mapping that individual's respective hits to a particular website, following that individual on the social networking site, sending some spam mails whatsoever to that individual. I mean, you are trying to keep a watch on that individual by whatever way it is possible. So like that kind of crimes we call as cyber crimes against the person. Second one, property. You are trying to misuse the property of an individual. You are trying to commit a mischief with reference to that property. You are trying to steal that property, damage that property, right? And this property need not be property possessed online. It could also be property which is present in the physical form, right? By using cyber means, you can commit a theft or you can commit a crime in the physical world as well, right? In that case, for that crime in the physical world, your cyberspace is giving the aid, giving the assistance, providing the platform. So you are also jointly, vicariously, indirectly responsible for that crime. We call it as vicarious cyber crimes or joint crimes or joint responsibility with reference to the crime committed where you have drawn support assistance by means of cyber, right? Cyberspace. The third one, cyber crimes against reputation. Here you are trying to tarnish some individual's reputation. You are trying to target that individual's name, goodwill, right? Let's say reputation need not be confined to a physical individual. Reputation may also be with reference to a particular institution, a particular entity, right? For example, your institution. And you are trying to harm the reputation of your institution by posting some adverse comments about your institution, about a particular organization, a particular company, a particular corporate entity, right? So, some or the other way, you are trying to tarnish the goodwill, image, reputation, name, fame of either individual or entity by using cybercrime or in the cyber platform that we call as cybercrime against reputation. And the last one, cybercrime against the society, the public, the masses, and the state, including the government, right? When we were trying to instigate masses, like it happened during the times of last year when in Jammu and Kashmir, people were pelting stones against armed forces through WhatsApp messages, through Facebook posts. People happened to share that Indian Army is trying to conquer the other part of Kashmir. Indian Army is coming to trash the youths of Kashmir. Indian Army is against, say, a particular community. Like this kind of posts were kept on Facebook, LinkedIn, Instagram, or even WhatsApp. That's the reason why for about 1 year, cyberspace or internet was prohibited in Jammu and Kashmir. Even now, there is only 1G or 2G available in Jammu and Kashmir. For more than 1.5 years, cyberspace was prohibited. Our internet was not allowed for use in Jammu and Kashmir. Yes, because of this kind of cybercrime. Cybercrime, against you are spreading false news. You are instigating people by using the social media platform, cyberspace platform. You are trying to use the cyber tools for the purpose of spreading hatred against the people, against the society, or against the state. That kind of crime we categorize as cyber crime against property. Now let me take you through some existing laws with respect to how these 4 different categories or 4 different classes of cyber crimes are actually attempted to be controlled by the law. As far as cyber crimes against the person are concerned, we have got information Information Technology Act, which was enacted in the year 2000, of course, amended and updated in the year 2018. So we are completing 2 decades of this Information Technology Act, which has been brought into existence for the purpose of regulating information technology, regulating cyberspace, and also for controlling cybercrimes. This first category of cybercrimes, as we mentioned, cybercrime against person. I have got certain things to say with reference to the Information Technology Act. Right? If it is a crime against a person in the physical world, you do not apply information technology law, but you have applied Indian Penal Code, Indian Criminal Law. But here we are confining only to the cyber crime against person or crime against person in the cyberspace. So, cyberspace regulator is Information Technology Act in India. Please remember, cyberspace regulator in India is Information Technology Act. Whatever is taking place in cyberspace, we are controlling, regulating through the length of Information Technology Act, right? So, with reference to the crime against the person by using the cyber means, by using the cyberspace, we have got certain provisions, certain sections of the so-called Information Technology Act. There are certain identified crimes against person by using cyberspace, like spamming, like hacking, like password breaking, like stacking, keeping a whistle, keeping a vigilance on the individuals or entities by cyber means, right? These kinds of crimes, which we have categorized as crimes against the person by using cyberspace, there are a couple of sections under the Information Technology Act of India which talk about punishing this kind of cyber crimes. For example, hacking. What do you technically mean by hacking? Gaining access to someone's personal account on computer network. This is how we lawyers are. This is how hacking is understood from the length of the law. There may be some serious technicalities involved in it. One needs to be seriously possessing technical expertise to execute this act of hacking as well. That's why in the cyberspace, generally in the legal practice, we say that it is possible to only those sophisticated technocrats to commit cyber crimes, right? Unlike the crimes in the physical world, where uneducated people are people who do not have staple food, are people who are habituated, who do not have any other work, right? They're actually habitual in committing substantially 90% of the cases. But in the case of cyber world, it is the only sophisticated technocrats who are extremely highly qualified handling computers and technology. They only can commit, if not committing, help assist, provide a platform for the committal of cyber crimes. So it is that's why we call these crimes as techno crimes, right? Techno crimes, white collar crimes, sophisticated crimes, techno crimes, and technologically driven crimes, right? So hacking, that is nothing but gaining access to someone's individual personal business accounts and computer network. It is actually prohibited under Section 66 of the Information Technology Act, and it prescribes imprisonment, child imprisonment for a period of 3 years. Any crime against a person by using cyberspace, these generally involve Section 66 or Section 72 of the Information Technology Act. It need not be just hacking. Any kind of crime against individual person by using cyberspace, we invoke or we apply these two sections, Section 66 and 72. Any kind of techno crime that you talk about, hacking, password breaking, stacking, spamming, keeping a visual, following one individual on a social networking site, sending spam mail, following continuously poking or continuously following some individual on say your social networking sites, right? All these kinds of personification are violating the privacy of some individual online, trespassing into the personal domain of that individual, right? We call these types of crimes as cyber crimes against the person. For controlling these kinds of crimes, we generally invoke Section 66 and Section 72, which talk about the which we label as crime against person by using cyberspace, or cyber crime against the person. We generally invoke section 66 and 72 of the Information Technology Act, because under these lines, Information Technology Act talks about ensuring privacy online, ensuring privacy online, ensuring personal domain of you people, individual or entities, whoever is having their presence in the online world, ensuring their private domain, ensuring their privacy online. And if you are disturbing their privacy, if they are entering into their personal domain, then you are committing a crime against that individual's privacy, personal domain, or codification, and for that you are subject to the application of Information Technology Act respecting section 62 or 66, which can be punishable with an imprisonment up to 3. The next one, crime against property, cyber crime against property, right? Committing property-related offences by using cyberspace. Committing property-related offences by using cyberspace, or through the means of cyberbullying, like theft online, cyber fraud, forgery of electronic documents, or like destructing, damaging digital information, erasing information that you have kept online, or are trying to play with the digital or electronic signatures, because digital signature or electronic signature is also a property. So any property, it could be possessed in the physical world or it is possessed in the online world. Properties like your password, your digital signature, your electronic signatures, they are all properties, right? They have been sanctioned to you by certain authorities and you have expended money, time, energy, everything into it, right? So it's your property. Similarly, your data, information that you have stored on your computer, on your laptop, on your Google Drive, or other electronic means, all that is your property, which is kept online, which is having its own diverse presence only, doesn't have any material presence, physical presence, right? So your offense may be with reference to the property that you have kept online, like I mentioned, information stored in the online world, right? Electronic signature, digital signature, your password, these are all having serious, not only technical value, but as the commercial value. It's nothing but your secret information, secrecy about your business entrepreneurship. All that is property, including your patent rights, copyrights, trademark, all that have got no physical existence. You are possessing it, right? You are experiencing it online, right? All such non-material form-oriented property. If you are trying to damage, if you are trying to steal, right? If you are trying to enforce upon, misuse, it is termed as cybercrime against the property. Not only that, cybercrime against the property can be committed in the physical world also. You can damage the property in the physical world by using cyberspace, right? Nowadays, entities are managed by software. Business methods are developed, right? By using business methods, you are controlling, you are maintaining the business. It could be payment of your salary of your staff. It could be maintenance of attendance of your staff or your students. Or it could be taking the stock of the property that you are possessing in your entity. All that is taking place in the online world able through the business methods, software or artificial intelligence, right? Including robotics. Through these artificial means, technical means, you are now controlling not only individual entities but as well government even, right? So artificial intelligence presence is there, which is also resulted not only in benefit to the society but as well damage to the society. For example, you must have seen the big giant producer Shankar's movie Robo 1 and Robo 2.4, right? Where this use and misuse of your artificial intelligence or mechanical intelligence, including your computer intelligence, information technology misuse, right? Happening, damaging the society, damaging the property, damaging even the state, everything, right? Huge amount of property getting displaced. So what I'm trying to say is, not only this offense can be committed with reference to properties that you have stored use it in online, but as well in the physical world, right? If you are using a robot, or if you have an artificial intelligence, right? You will fine tune, you will install a software, or you will program it in such a way that it goes and damages a particular building. It goes and damages a particular property, right? But damage is happening in the physical world. But who is doing the damage? Some artificial entity. Or that artificial entity is controlled by your computer. Now that artificial individual is controlled by your artificial intelligence. And who has designed that artificial intelligence? A technocrat, right? So technocrat is having physical presence. And that technocrats that is the intellectual action is not having physical presence by means of developing a method, software, artificial intelligence, a robot, etc., and that is damaging the properties in physical world. So cybercrime is crime against the property in the physical world, crime against the property in the cyber world. Both can be committed by using your artificial intelligence, by using your computer program, by using your computer methods whatsoever. And all that is controlled, attempted to be controlled, prohibited under the Information Technology Act. If you can look at my slide here, slide number 9 I have given, I have mentioned about not only the respective sections of the Act which talks about controlling, prohibiting cyber crimes against the property, but as well it talks about the imprisonment and the fine as well. For example, theft online, cyber fraud, forgery of electronic documents, and misuse, destruction of digital information like cyber crimes against the property. Section 74, Section 65 of the Information Technology Act talks about not only punishment, penalty, etc., etc. It also prescribes the modes and means by which you can control, you can prohibit, you can punish the attempt against the property by or by using taking you further. Cybercrime against reputation, name, fame, goodwill, image, whatever you have got. You get here, your name, fame, goodwill, image doesn't have any physical existence. We have physical existence. Entities have physical existence, but the name, fame, reputation, goodwill doesn't have any physical existence. It goes by mouth talk, right? It goes by experience, right? You feel it, you garner it, right? But you cannot possess it. Like you possess your mobile phone in your hand, you cannot possess it. Mobile phone you can possess. That is the property. But your goodwill you cannot possess. You cannot feel the, you cannot experience the physical presence of that goodwill. Same is with your name, fame. I'm not talking about your individual name. The goodwill is associated with that thing. The good things which are associated with that thing. For example, now your Siddaganga Institute of Technology. Siddaganga is not only famous for imparting education, but it's also famous for charity across Karnataka and beyond. Siddaganga is famous for not only education, it is famous for charity, social activities, right? The moment you talk about Siddaganga, not only that living God who is no more now, unfortunately, not only they remember him, but as well the service that he rendered to society, through education, through catering to these various needs of the people, food, educating masses, providing food to the people who are not having food, right? Not by just by his own property, but as well as pulling the governments across, right? So that kind of name, reputation, goodwill, Siddaganga name is having. Likewise, individuals may be having their own name, entities may be having their own name, and that when you grow beyond your name kept to you by your mother and father, then you are said to have garnered your reputation and goodwill, right? When you are confined with the name given to you by your parents, that is not the name that you have earned in society. I am talking about the name that you have earned in the society by your action, by your deeds, by your personality. That kind of name, that kind of fame, that kind of goodwill, reputation, right? When it is garnered, established by not only by physical means but as well by cyber means, one can spoil, right? I can post one particular message on WhatsApp or Facebook by which I can harm an individual's or entity's reputation, right? Just with the click of mouse click, I can do that. I can post in your name. I can go about posting a pornographic picture, an obscene image in your name. By that, what will happen? Whoever visualize it, whoever download it, whoever follow it, right? They will individual and that militant, right? Or like that, this kind of actions when we do, right? Doing something which is obscene, posting pornographic material, obscene material, publishing something which is hatred, right? Against the name of that individual, right? You may be a professor in the computer science. I will do something, I will mention your name and I will say that you are professor in robbery. You are a professor in bribery.